Coffee Hour. Welcome to Coffee with our morning host. We broadcast a host of programs like current topics, newspaper headlines, and music on Radio Sri Lanka. Tune in every weekday from 7 to 8 a.m.
We will be in conversation on a matter of intrigue and interest. And on the program with me is Professor Kokila Konasinghe, the Department of Public and International Law, Director of the Centre for Environment, Law and Policy, Faculty of Law, University of Colombo. A very good morning to you, Professor Kokila.
Good morning.
And may I take this opportunity to thank you for starting your day with us to give us your valuable insight in environmental law.
It's a pleasure, Soundi.
And starting at the very beginning is the very best place to start, isn't it, Professor Kokila? So when we talk of environmental law, can you tell us what exactly we're talking of? What exactly is environmental law?
Yes, that's where we should begin actually, because I think in Sri Lanka, many people do not have much understanding on what is environmental law. So I think this legal awareness on environmental law is very, very important for a country, a tropical, beautiful island like Sri Lanka. And what are the legal parameters and protection available for the natural resources in this country. And also we are one of the biodiversity hotspots in the world. And also we are highly and adversely impacted by the climate change as an island nation. So I think we are starting with a very important topic for the entire nation, that is what is environmental law. So let me start saying that the geopolitical, social, cultural and economic context where we see environmental law is very vital to understand. And as a developing country, we are at a position that many laws are there, but there is a big problem with the implementation up to the expected level. So what is environmental law? Now we are facing so many natural disasters and climate change catastrophes or plastic and polythene menace. May that be any environmental problem, now the adverse impact and the harmful effects of environmental pollution now is at our doorstep. So no longer we can say that Sri Lanka is very rich in natural resources, so we are very happy and we can rest. We have many environmental problems. So the law that addresses these problems, causes of environmental problems, and analyze the impact of it and find solutions to minimize or prevent these environmental damages is called environmental law.
Right, so in brief, that's what we are talking of, the environmental law, kind of like rules, regulations set in place to make sure that we preserve our environment. Right, and how does it actually help us protect the environment, Professor?
Yes, now let's think about environmental problems and the causes and effect of these harmful threats. Now, from dengue menace to climate change, if we look at a very wider dimension, from local problems to global problems, we are as human beings equally affected. Mm-hmm. So there should be ways and means that to prevent. First of all, we must look at prevention, and then we must see how to mitigate and adapt, and also how to make the minimum impact for the survival of human beings and the nature. Now, when we look at this, how we protect Saundi, we have two approaches so far that environmental law has taken. So, ever since the development of environmental law, we see that there are two approaches. One is human-centered.
Right.
Laws, regulations, rules have been created based on and focusing the human-centered aspect. So, what impact on human beings and what benefits we can get from natural resources. That was the main focus within the discourse of Anthropocene or human-centered focus. But the novel approach or the modern or perhaps the way forward would be ecocentrism. That is, we take the human beings as just one species of the entire biodiversity. And when we make laws, regulations and other related parameters, we look at the entire ecosystem as one, not particularly human beings.
Right.
So I think the climate change has taught us a lesson that we should shift from this anthropocentric approach to ecocentric approach. So when we look at how environmental law protect us, we can see many laws and regulations at the local level and also at the national level, regional level and global level. The beauty of environmental laws is that we cannot differentiate between any of these, because we are ultimately a very vulnerable species in the entire ecosystem. So can we say that we have Sri Lankan environmental law? So if we fulfill only Sri Lankan environmental law, are we safe? No. Not at all. Because environmental problems are universal, transboundary.
Right.
What happens in Delhi, in India, affects Colombo in Sri Lanka. Likewise, North Pole, South Pole, wherever environmental damage is caused, the impact would definitely affect the entire Earth, entire human population and fauna and flora. So therefore, we have to see the protection of environmental law from a larger perspective, bigger picture. That is where we miss as a developing nation, and that is where we miss as Sri Lanka. I think we have to look beyond the territorial boundaries and see how we can contribute to the global protection dialogue, as well as how we can be benefited from the global standard. So I think that is where we have to look at when we think about how we can be protected from environmental laws.
And when we talk of environmental laws, Professor, just to expand on it, these are now pertaining to Sri Lanka. From a local perspective, I know there are many environmental laws, I guess enacted, isn't it, and passed into law and also enforced. To what extent is it enforced, and are there penalties involved? Now when we talk of, we'll say within our territorial waters, within our four corners of the island, if there is a environmental issue, maybe pollution caused by somebody or an entity, how strong is the law there, and how does it apply? In what way will it apply in a particular scenario?
Yes, it's a very fascinated question to explore, because I, as a researcher in environmental law, have studied more than 100 laws, statutes are there to protect environment in Sri Lanka. But are we protected, and are we doing enough? That is the question. So if I may start with the supreme law of the country, that is the Constitution, 1978 Constitution, we have Chapter 6, Directive Principles of State Policy. Under this chapter, the government, the state as well as the people of the country are directed how to make policies and how to regulate certain areas of governance. One area is environment and the natural resources. Under Article 27(14) of the Constitution, the state is responsible, and it says like this: the state shall protect, preserve and improve the environment for the benefit of the community. Therefore, the state has an obligation and responsibility as a governance mechanism to make sure, to ensure that the community is safeguarded from environmental pollution. And interestingly, on the other hand, under Article 28F, it says it is the duty of every person in Sri Lanka to protect nature and conserve its riches. So this is a very interesting argument that comes under the social contract, that we always say that we hand over the sovereignty or the power to make laws, interpret and implement to the government by our votes. So why the government can't fulfill those obligations? But we can very well see Article 28F enforce people a duty, and the people have the duty, every person in Sri Lanka, not only citizens, whoever lives in Sri Lanka, that person has a duty to protect and conserve nature and its riches. So this is where we see the social responsibility, collective responsibility of the government as well as people of this country. We always used to point the finger at the government and blame the government for not doing enough. They have the responsibility as well under this provision in the Constitution, as well as people. So that is why I said that nobody can say that if we protect our piece of land, we are protected. No, this should be transboundary, and also every environmental problem is interdependent with each other. So it's a cross-sectional responsibility that we have to aim at, and also collectively we have to face this as a government and also as people of this country. So that is under constitutional law, which is the supreme law of the country. And there are also, in addition to the constitution, various statutes, we have so many legislative provisions to protect environment, starting from National Environmental Act, Fauna and Flora Protection Ordinance, Forest Ordinance, Coastal Conservation Act, Marine Environmental Protection Act. Likewise, we have so many laws, statutes to protect various areas of environmental and natural resources. But the problem is that some of those were drafted and adopted during the colonial time. So some of the names, when I mentioned that ordinances, those were under the British colonial time. So there are plenty of areas that need to be updated. So I think it is high time for us to analyze these laws and see whether they are capable of addressing the contemporary issues that we are facing today, contemporary challenges, particularly the challenges coming from the climate change and biodiversity depletion. So those issues that we need to address, and this was quite evidence that when the Express Pearl incident happened, that we were not up to the expected level to mitigate that problem, to face that challenge immediately. So that is where Sri Lanka needs to improve. And in addition to that, there are so many cases, judgments given by the Honorable Supreme Court as well as Court of Appeal, and also there are so many laws under the criminal law which is operated under magistrate court. So likewise, we have so many laws in place, constitution, statutes, case laws. And in addition to that, under international environmental law, we have a very interesting area called concepts and principles of international environmental law. So perhaps we can discuss further on that and then discuss further on that because it's very important. Some of the laws that has been enacted are entirely based on these concepts and principles.
Right.
Likewise, intergenerational equity principle, common but differentiated responsibilities principle. Now, these common but differentiated responsibilities is the dominated concept in the climate change. Paris Agreement, Kyoto Protocol, United Nations Framework Convention on Climate Change, everything is based on these common but differentiated responsibilities, which says that all countries face the problem in a common manner. And we have to be responsible in a common manner. But the responsibility is differentiated depending on the economic, social and political capacity. So likewise, we have precautionary principle, polluter pays principle, and these principles are enshrined in the Constitution and many other laws on environmental protection.
Right. And Professor, before implementing this law, how was the environment protected? Because laws came in at maybe a particular time, isn't it? So before that, what was the scene like? Like, of course, the environment has been protected for years and years, isn't it? Because that's why we have it still with us today.
Yes, that is very fascinated area, Saundi. If anyone can explore how we protected the environment during the ancient kings' time.
Yes.
So now, if we look at this phenomenon, that how we protected environment, how the environment was survived and how people were survived and lived in harmony with nature during the ancient time. It shows us that the environmental law can be divided into two. Mm-hmm. That is ancient approach and modern approach. So if I may start with the ancient approach, look at Parakrama Samudraya and many other irrigational and also cultivation mechanisms that had been practiced during the ancient time, which are very, very environmental friendly. And this was in fact referred by International Court of Justice in one of the prominent case by one of the prominent Sri Lankan luminary who was then Vice President of the International Court of Justice in 1997 in a case called Gabchiko Nagimaru's case, Hungary versus Slovakia.
Right.
And in this case, Judge C.G. Veeramantri stated, and he referred to many ancient scriptures like Mahavansha and Thupavansha in Sri Lanka. And he showed how the Sri Lankan irrigation system and mechanisms and also traditional knowledge contributed for the sustainable development. So the development projects took place under those rulers are still in use. Now we still use for cultivation the water from Parakrama Samudra. So it's amazing how it was survived for thousands of years. And the most interesting thing is it never occurred any damages to the environment. So how do we do the development in harmony with nature? So we can't say that we have to preserve the environment as it is. No, it is not a realistic approach. The realistic approach is sustainable development. So we have to save this environment for the benefit of the future generations, at the same time using it for the present generation's developmental needs. So that is where we have largely failed under the modern approach. And also the traditional cultivation methods such as now if you look at chena cultivation. So before you burn the forest to have the chena, the first thing you do is you make loud noises and then chase away all the biodiversity.
Yes.
So was it just out of the silliness of the farmer? No, the traditional farmer has that wisdom and commitment towards protecting biodiversity. But before they use the land, they protect the biodiversity. So likewise, I can think of many examples, and I'm sure the listeners also must have a lot of experiences in the traditional system in Sri Lanka, and particularly South Asia. We have a very rich heritage of environmental protection. So environment was protected, and also ancient kings took many rulers, had many policies in place, many systems in place to ensure that the environment is protected despite the development projects are conducted. So that is where we have to actually move as the modern nation. Now, if we move on from there onwards, in the 14th, 16th, 15th centuries in Europe, we had industrial revolution. Right. So we extensively used the natural resources for the development process, industrial process, without considering that we have to save it in a sustainable manner. So I would like to share a very significant landmark incident which happened in US, and in 1962 there is this publication called Silent Spring by a scientist, a female scientist called Rachel Carson. Rachel Carson's Silent Spring is all about scientific data and findings, which says that how devastating the use of pesticide in the US for cultivation. So to destroy certain insects that is harmful to the cultivation, they use this DDT through aerial spray, and the entire population of birds were affected. And then a committee was appointed to investigate into this, and Rachel Carson was one of the scientists in the committee, and she published this book called Silent Spring. The spring is silent because the birds are all gone. Mm-hmm. So then the Western world, for the first time, because they never realized that how destroyed that they are, how damaged that they cause by industrial process. But this book, this particular publication, opened the eyes with alarming findings. So after that, the modern approach to environmental protection began, and then for the first time, the global community under the United Nations had its first conference on environment in Stockholm. It is called the United Nations Conference on Human Environment. So that's how the modern approach began. So before that, I think with the traditional knowledge and the traditional approach to environmental protection was rather that it's very peaceful, and also it shows that we have to live in harmony with nature, and we are just another species in the entire ecosystem. So we had the respect, dignity towards the nature, and also the religious concepts. All religions, as recently in 2022 in Vilpattu judgment, Justice Janak de Silva very vividly explained that how religious concepts, Hinduism, Islam, Buddhism and Catholicism, all religions had their values placed in environment, natural resources. So the sun, moon and rivers, water, we consider as divine.
Yes.
So that close connection, interconnection between humans and nature was survived before all these laws came into action.
That's right. And when you mentioned Parakrama Samudra, I wouldn't know, and I don't think King Parakramabahu had an LLB now. Would you think so? I don't think so, but still, as you say, they live with nature and use their wisdom. And
yes. Yes, I think the rulers should not limit their knowledge to degrees or diplomas, but they should look beyond that as rulers, because the governance should be always multidisciplinary, and it should not only limit to law or only limit to politics. It should be much more diverse and broader perspectives.
Not that we have anything against it. It's superb to get all the degrees and qualifications, but still, as you rightly mentioned, going hand in hand with nature. And I'm in conversation with Professor Kokila Konasinghe, our guest today, to discuss environmental laws. Well, Professor Kokila, coming back to our conversation, we just celebrated World Environmental Day this month, earlier on in the month. And what would be the steps taken in the judicial system to protect the environment and in relationship to World Environmental Day?
If you look at first the World Environmental Day, the theme of this year's Environmental Day was to prevent the damages or the pollution caused by plastic. So this single-use plastic and other elements of it has caused adverse impact for various environmental problems, not only just pollution. And it is very dangerous because it cause so many problems for the future generation, not only for the present generation. Mm-hmm. So the cause and effects are relatively higher with plastic and polythene. Therefore, the main theme was on that for the World Environment Day, and I noticed that many initiatives were taken by the Sri Lankan governance mechanisms as well towards protecting the nature and the coastal areas and also the land of Sri Lanka from polythene and plastic. The next part of your question was based on this judicial approach, mm-hmm. which is one of my very interesting areas to discuss. Saundi, now the application of law or creation of law for the protection of anything, including the environment, can be twofold. One is the Parliament can pass the acts, mm-hmm. statutes. So the legislature can pass legislative enactments and regulations and acts for the protection of the environment. Mm-hmm. And most interestingly, the other way of doing that, which may not be as time-consuming as the Parliament procedures, and also environment is an area that require immediate action, because other than other laws, this directly affect human survival and the survival of the entire nature, as well as no matter how much we protect other rights or how much we develop, we can't get away if an environmental problem occurred, and then the entire human beings will be gone. Therefore, the implementation of law in environmental area should be very updated and also very efficient. So the second way of doing this is the judicial review, mm-hmm. legal interpretations. And I particularly look up to the honorable judges, judicial officers in this country, and they are also part of the government. And we have executive, legislative and the judiciary. So under the directive principles of state policies, where we just previously discussed that when the state is responsible for the protection and preserving environment for the community of this country, the judiciary, honorable judiciary is also part of that. So they have a responsibility towards this. So rather than waiting for a statute to come out, yes, after passing a long procedure and also and lot of arguments in the parliament, and also finally when it comes, perhaps the damage has been already caused. But Honorable Judiciary can be very progressive in this approach of lawmaking. Therefore, let me focus on some of the important cases, judicial review, landmark judgments in Sri Lanka that any Sri Lankan should know about. So I think the discussion today will contribute for the knowledge of the general public of this country. And I really admire your program for that, because this is a very good platform that you can enhance the knowledge of the general public. So let me start with one of the landmark cases, and perhaps many of the listeners would know this case called Eppavala case, famously known as Eppavala case. Mm-hmm. And this was held in year 2000, and the Supreme Court, the Honorable Justice A.R.B. Amarasinghe's judgment is recognized worldwide, and the case the formal name is Bulankulama versus the Secretary of the Ministry of the Industrial Development and others. So this Bulankulama case, or famously known as Eppavala case, has contributed immensely for the development of environmental law of this country. And the Honorable Justice Amarasinghe enhance the concept of polluter pays principle, sustainable development concept, intergenerational equity concept through this judgment. And also this whole case on Eppavala set the standard for the Sri Lankan judiciary to look up to implementing and incorporating international law, international legal principles into the national legal framework. When we see the Parliament doing this, it is a very hard process. It's very time consuming. Therefore, with all my respect, I would like to remind this again and again that this Bulankulama case, Eppavala case, contributed immensely for the development of environmental protection. And there is another case in 2007, Wattegedara Vijay Banda versus Conservative General of Forest Department. And there, Justice Shirani Tilakavardhana, the Honorable Justice, former Justice, stated that the right of all persons to the useful and proper use of environmental and conservation thereof has been recognized as universal and also under the national laws of Sri Lanka. So it's a very brave approach, I would say, that the judiciary took in this case. The right to clean environment and the principle of intergenerational equity with respect to the protection and preservation of environment are inherent in a meaningful reading of Article 12.1, which is talking about equality and non-discrimination of people's rights. So, Honorable Justice Shirani Tilakavardhana referred in the Article 12.1 reading as a framework. She built up a framework to protect the equal rights of people, in a way ensuring that the right to a clean environment. So which is a very progressive judgment, I would say. And also in 2019, Ravindra Gunawardena Kariyavasam versus Central Environmental Authority and others, Justice Prasanna Jayawardena, Honorable Justice Prasanna Jayawardena in the Supreme Court held that access to clean water is a necessity of life, and inherent in Article 27(2)(c), where it declares that state must ensure the realization by all citizens of an adequate standard of living for themselves and for their families, including adequate food, clothing and housing. Now, nowhere in the Constitution this particular economic, social, cultural rights are enshrined explicitly. But by the judgment, this is famously known as Ravindra Gunawardena Kariyawasam case is famously known as Chunnakam power plant case in 2019. And this case stated, Honorable Justice Jayawardena stated that this covers the economic, social, cultural rights of the people of Sri Lanka. So that way the Supreme Court developed environmental law. And then finally in 2022 the Court of Appeal of Sri Lanka, Honorable Justice Janak D. Silva mentioned in the Vilpattu case, famously known as Vilpattu, Centre for Environmental Justice versus Conservative General of the Department of Forest Conservation and others. So in this case, they applied the international environmental concept called polluter pays principle. Whoever caused the damages should pay the cost for the environment. So there also, he referred to Article 28F of the Constitution and said even a cabinet minister is responsible for the protection and preserve of the natural resources of this country. So likewise, it's very interesting that how the judges made law. So this all these cases, and including the Easter bomb case, recent case judgment, the Supreme Court held that the right to life, because the Constitution does not enshrine the explicitly right to life in Sri Lanka. There is no provision in the Constitution to ensure right to life. But the 7-bench judgment in Easter bomb case ensured right to life. So likewise, the judicial review contributed immensely for the protection and promotion of environmental rights of the country and the people.
So they played a huge role in like putting in the missing parts and the pieces of the jigsaw to complete the environment, the law part of protecting the environment. Is there anything else you would like to add, Professor?
Yes, finally, now I would like to say that now we have been talking about right to environment. So again we go, we talk from the Anthropocene perspective. We see what rights can humans achieve for environment. So we say right to life, and we extend that right to live in a clean environment. To whom? For people, for humans.
That's right.
But now the world legal interpretation and the legal scholars are moving from this approach, right to environment, for the rights of environment, rights of nature. So that is where the world is moving. So for the Sri Lankan, the nation, I would say that it is high time that we should consider not only right to environment, but rights of nature, where we discuss the natural objects like perhaps the river or the mountain has equal rights to human beings, because they are also part of the nature. So if you look at the international legal interpretation and the scholarly writing on this, we can see that there are statutes. In New Zealand, we have Wanganui River Claims Settlement Act in 2017, where the New Zealand Parliament stated that, and they adopted this statute, and then stated that the Wanganui River is a legal person. So, Wanganui River has right to preserve, protected, and evolve.
Right.
Which is an amazing concept. And also not only statutes, but also case law. If you look at neighboring India, we have so many cases, particularly Muhammad Salim and Lalit Miglani, the Uttarakhand 2 cases, Uttarakhand High Court judgments are recognized worldwide for their acceptance for river Ganges and Yamuna as legal persons. So that is a very, I think, giant leap in terms of legal interpretation. And also, interestingly, there are constitutions that adopted this approach, rights of nature. And in Ecuador, Article 71 considered as nature has life and it can reproduce and protect and conserve, and also all the people in Ecuador are required to respect and protect the existence and the maintenance of the regeneration of these natural phenomenon, and they believe that they have life in it. Right. So likewise, we have so many statutes, constitutional provisions and case law has developed towards protecting rights of nature. So if we look at the Vilpattu judgment, we can see that there are so many rights and regulations to protect Vilpattu forest from human perspective. But what would the Vilpattu forest think about that devastating deforestation?
That's right.
And the biodiversity? What would a small insect in that forest would think about what happened? So would they have right? So that is where, we are too early, and it's too early to understand this phenomenon of rights of nature. But I would like to conclude with that whole idea of rights of nature, because that is the contemporary development that is taken place in the international legal scholarship. So with that, I think we can conclude. And also there are so many other contemporary developments on the, if I may briefly say, that public-private partnership also very important in particularly in the climate change discourse. Prototype Carbon Fund, Rainforest Trust Fund. Right. So likewise many private organizations, and not only private companies but also non-governmental organizations and non-state actors, even private individuals contribute and influence for the lawmaking process at the global level. So I think that is what we can say about it, about the contemporary development. So
that's right. It has been a very interesting conversation on Coffee Hour. Thank you very much. And I've been in conversation with Professor Kokila Konasinghe, Head of the Department of Public and International Law, Director of the Center for Environment and Law and Policy, Faculty of Law, University of Colombo.
The Coffee Hour. Welcome to Coffee with our morning host. We broadcast a host of programs like Current Topics, Newspaper Headlines, and Music on Radio Sri Lanka. Tune in every weekday from 7 to 8 a.m.